What unfolded this morning marked a moment few expected and even fewer were prepared to witness. To understand why it matters, the legal context cannot be ignored. Federal prosecutors have been investigating Donald Trump for obstruction of justice tied to classified documents recovered from Mar-a-Lago. Their central claim is straightforward but severe. Trump knew he had classified materials, was instructed to return them, refused to do so, and then directed others to conceal those documents from federal investigators. The evidentiary record is already deep. Surveillance footage, statements from employees, and documentary proof showing possession of materials he was not authorized to keep. But the government wanted something more decisive. They wanted proof of intent, proof that Trump understood his actions were illegal, grasped the consequences, and proceeded anyway. To establish that, they needed testimony from someone who had spoken with him directly, someone he trusted, someone present during private moments when the issue of the documents was discussed. That person is Barron Trump. Barron has lived at Mar-a-Lago with his father since Trump left office. He was present during family conversations, present when attorneys met with Trump, present in the residence where classified materials were allegedly kept. Prosecutors believe Barron overheard discussions about the documents, that Trump may have spoken in front of him about what to do if federal agents came looking for them, that Barron possesses information relevant to the investigation. Under federal law, there is no parent-child testimonial privilege. If prosecutors believe a witness has relevant information, they can compel testimony. Even if that witness is the defendant's son, even if the witness has just turned 18, even if compelling that testimony risks destroying a family relationship. Trump's legal team challenged the subpoena aggressively. Emergency filings, arguments that forcing his son to testify against his father violated basic fairness, claims that it would cause irreparable emotional harm, assertions that Barron had no relevant information to offer. None of it worked. The judge reviewed the government's proffer, outlining what prosecutors believed Barron would testify to, and ruled that the testimony was relevant and material. The subpoena was valid. Barron would be required to testify. If he refused, he could be held in contempt. This morning's hearing was expected to be routine, a status conference on scheduling and discovery. Instead, prosecutors informed the court that Barron had been served with a subpoena and would be deposed next week. Trump's attorney objected instantly, requesting an emergency hearing. The judge declined. The subpoena had been properly issued. Service had been completed. Barron would testify. Trump, seated at the defense table, visibly lost color. He leaned toward his attorney, spoke quietly. The attorney shook his head and replied. Trump stood as if to address the court, but before he could say anything, his legs buckled. He collapsed back into his chair, hit it hard, buried his face in his hands, and began shaking. Not sobbing, shaking, his entire body reacting like someone in shock. The judge immediately called a recess. Marshals approached, asking if medical attention was needed. Trump waved them away, but he could not stand or regain control. His lawyers closed in around him, attempting to shield him from cameras and calm him down. Witnesses later said he kept repeating the same phrase, "Not Barron. They can't do this to Barron. He's just a kid." His attorneys tried to explain that Barron was 18, legally an adult, that the subpoena was lawful. Trump did not appear to register it. This was a father realizing his youngest son would be compelled to testify against him. And that realization shattered something. Here is what that means legally. Barron will sit for a deposition next week in a room with prosecutors, a court reporter, possibly federal agents. His own lawyer will be present, but Barron will be required to answer questions under oath about conversations with his father, about what he observed at Mar-a-Lago, about whether Trump discussed the classified documents with him, about whether Trump said anything about hiding them or refusing to return them. Every answer will be transcribed, every word preserved, potentially introduced as evidence at trial. If Barron confirms Trump knew he possessed classified documents, that testimony is devastating. If he recounts discussions about concealing them, that establishes obstruction, and it comes from Trump's own son. The psychological impact is impossible to ignore. Trump has endured investigations, indictments, courtroom battles. Through all of it, he projected confidence and defiance. This is different. This is not about his own exposure. This is about his child being pulled into a federal prosecution, forced to answer questions that could send his father to prison, and there is no mechanism to stop it. He cannot pressure prosecutors. He cannot sway the judge. He cannot make this disappear. Barron will testify, and Trump must sit with the knowledge that this is happening because of decisions he made. Trump's relationship with Barron has always been distinct. Barron is his youngest child by a wide margin. During the presidency, he was largely shielded from public scrutiny, kept away from political spectacle. Trump has been intensely protective of him. That protection no longer exists. Barron is legally an adult, subject to compulsory process, and there is no barrier Trump can place between his son and federal investigators. That loss of control is what triggered the collapse, not fear of conviction, but the realization that he could not protect his son from the fallout of his own choices. The deposition will occur behind closed doors. The transcript will be sealed initially, but if the case proceeds to trial, portions could become public. Barron may ultimately have to take the witness stand, swear an oath, and answer questions while his father watches. Defense lawyers would cross-examine him, challenge his memory, suggest confusion or influence. But if Barron testifies honestly about what he saw and heard, that testimony carries unique weight. Juries understand the gravity of his son testifying about his father. It is not taken lightly. There is also uncertainty about what Barron will actually say. Prosecutors believe he has relevant knowledge, but they do not know its precise content until he is under oath. He may corroborate their theory. He may say conversations occurred that showed Trump knew his conduct was illegal. Or he may say he does not remember that discussions were vague, that he was not paying attention. Trump has no way of knowing. He cannot discuss testimony with Barron without risking witness tampering. He cannot prepare him. He cannot influence the outcome. He can only wait. Images from this morning are already spreading. Trump slumped in his chair, shaking, surrounded by lawyers. For longtime observers, it was something new. Vulnerability, not the cultivated image of strength, not defiance, but visible fear. Fear for his son, fear for their relationship, fear that his decisions had consequences he could no longer contain. That reaction was not calculated. It was not performance. It was raw. What comes next remains unclear. Barron will be deposed. Prosecutors will evaluate the testimony. If it advances their case, they will use it. If not, they may never call him at trial. But the damage is already done. A son has been subpoenaed in his father's criminal case. That fact alone leaves a permanent mark. How a family absorbs that is not something the law answers. Trump's lawyers will continue filing motions, attempting to suppress the testimony, arguing it should not be admitted, claiming it is fundamentally unfair to compel a child to testify against a parent. Courts have consistently rejected those arguments. Family ties do not create immunity. If a witness has relevant information, the system demands it regardless of emotional cost. On a personal level, this represents a kind of defeat Trump has not faced before. Political losses, business collapses, legal threats were all battles he could engage in, adversaries he could attack. This is different. He cannot fight a subpoena served on his son. He cannot redirect blame. He cannot exert leverage. It is total powerlessness. For someone whose identity is built on control, that is crushing. Observers said they had never seen Trump react this way. The breakdown was immediate and unguarded, a father confronting a consequence he never imagined. That his youngest son would be drawn into his legal crisis, not by choice but by force of law with no way to stop it. Barron will testify. The questions will be asked. The answers will exist. Trump will have to live with whatever those answers